Hey, everybody, this is Aaron and Chuck here. Put the right banner up for us here at Impact Litigation. We have this on our YouTube channel. I also have it streaming on my Facebook page because I normally do a 5 o'clock Facebook today, but I thought it was really important to get this out. Somebody complained that I hadn't tweeted about it, Aaron, but I've been in class all day. I teach from first thing in the morning in Emory Law School, which is not near my house. And I literally just got back to the office. This is the first time we've had to really chat about it. But we have posted a couple things online and we've talked to some press about it. Obviously, Aaron, we're disappointed in the decision. Not surprised in that we didn't get it on the 28th. If he was going to stop the lottery, he would have done it out on the 28th. So we weren't, given the fact he didn't, it's not a surprise that he ended up there. The opinion itself has really kind of three main points on this. And it is also clear that he wrote this on the 28th because that's evident in one of the footnotes. He had to go back and add a footnote to the case because of what the government did on announcing the lottery. So let's walk through this. And of course, we'll answer questions after we get through this. But at the same time, while I am disappointed that the court didn't see things our way, two good things happened. One, he basically ignored IT Serve Alliance and their motion. There's literally nothing in here about them. He granted their motion for summary judgment only because they wanted us to lose. But they're literally not mentioned in here at all. And none of their arguments are here. So that's a good thing. Second, we filed this to stop the lottery for this year. Both last year's lottery, try to save it, and to stop the upcoming. We didn't do that. But Aaron, there is change afoot, as they say. As a consequence of this litigation, somebody at USCIS woke up and they realized we have a massive fraud problem here. So they went out and they updated or created really the employer attestations, and they issued a policy announcement more than the attestation. So the attestation is you as the employer are not filing this application for this foreign national and you're not aware they're filing for anybody else. Now, if you were an honest person, you would make sure that you would talk to the foreign national and say, are you filing through any other employers? Okay. And if they said no, you would sign that. That's what an honest employer would do. But immigration doesn't necessarily trust that. So they created another policy that said, hey, Mr. Employer, if you own 10 companies that are related, you cannot file an H-1B for each of those in each of those companies for the same person. You can't do it. We are telling you can't do that. Now, oddly enough, that's a policy announcement, not a regulatory change. But what that's telling me, Aaron, and let me get your opinion on this, is that they're going to be looking for that in this current registration.
Oh, I think so. And they, we've also seen, we've seen the public facing stuff from the agency. We've also seen things that are less verifiable, at least from my end so far, about internal workings at the agency, that they are trying to put a lot more attention on this problem. And so I hope that is the case and that they're going to focus on trying to knock out some of this fraud. I mean, three lotteries here, and we still are not convinced that they're issued the full allotment of visas. Chuck, is that unprecedented?
Oh, well, as far as we know, it's unprecedented. But the problem is, for the last several years, USCIS has not announced how many new H-1Bs they've issued. Mm-hmm. They've just announced the number of H-1Bs, extensions, and new ones they've approved. So it's unprecedented, but it's more so unprecedented in the context of they're being challenged on this exact issue, and they're hiding the information. Why would they be? I mean, I don't understand. Just go public. Hey, and here's why they're not going public, because there's a massive amount of fraud. So they got, in Spanish, it's tienen vergüenza is what they've got. They got caught screwing up. So they're not announcing, hey, by the way, we let 85,000 people know in the first round, but only 40,000 sent notices, only 50,000 sent notices in. We don't know what those numbers are for rounds 1, 2, and 3 altogether. But as our clients have told us, There's no way they used all the numbers if the first and second round participation remained the same.
Well, and they're pretty sophisticated. They've run this program for a long time, and so they have formulas about how to decide how many selections to make, right?
Yeah, absolutely.
And so if there's any better indicator of large amounts of duplicate petitions and fraud in the petition in the system, I don't know what would be a better indicator of that than the fact that they can't use it despite going back to the well 3 times. They can't use the visas.
It's clear evidence that lots of employers, and at the same time, we have extremely low unemployment and employers screaming to hire people. So the combination of those two things clearly indicates that they screwed up, and they didn't realize it necessarily last year. Of course, we pointed it out to them, but now they do. Now, the other thing, Aaron, that we noticed is that in January, in their to-do list on regulations was, we're going to redo the lottery. So I would suspect, I don't know what it's going to look like. I don't have inside information on that, but I would suspect that if there is a lottery next year, and that's also up for we don't know, because Grassley and Durbin may change the whole H-1B program. But if there is, I can guarantee you it won't look like this. It's not going to. And the only reason that happened is this litigation. So in that respect, you lose the battle, but you win the war. Now, the bad part is the battle affects a lot of our clients who desperately need visas to stay in the United States. And for them, we feel terrible. So let's look at the decision. The court spends a lot of time, in fact, almost half the decision, talking about standing. Aaron, what's standing? Why is there so much time spent on standing?
Yeah, I mean, only a person who is directly affected by, in this case, a government policy is able to sue. And only a person who is being injured by the challenged policy is able to sue the government to challenge that policy. And so the question on standing is this person adversely affected? Are they suffering injury? And that was the terrain on which a lot of the battle was fought on the in the judge's opinion here.
You know, what's interesting is the judge, before he gets into that, lays out the facts. This is a motion for summary judgment, okay, which means there's no disputed facts. Aaron, I want to read you what the judge said the facts were in this case. The plaintiffs allege that the new rules make it easier to game the system because registrations are cheap and do not take long to file. They say H-1B consultancies offer to file fake registrations for a fee. A foreign national with multiple employers, real or imagined, filing on his behalf stand a much better chance of having H-1B select at least one of these registrations. He says the government argues no standing. So the government, they never contested what we said were facts. They didn't. These are basically uncontested facts in the case. We allege them, but the government doesn't oppose them, so they're facts. We then the case comes, okay? And so the government says, wait a second, you plaintiffs are not allowed to sue. You're not allowed to sue. Now, the judge already struck that down at the motion to dismiss stage. So I knew we were going to win this. But one thing we did to make sure is we got an affidavit, we got a declaration from an employer, from one of our plaintiffs that said, look, I intend to hire this person. We had a declaration at the motion to dismiss stage, and basically we had them repeat it with a different date. And the government said, this is actually what I find really kind of funny. The government said, well, all they did was change the date. And the judge was like, yeah, they still intend. And he went on for like 7 pages on this. Yeah, and that's fine because they intend to hire them. And I believe that because I don't believe you. You know, maybe that's not enough evidence, but I don't believe you because you can't conduct a proper lottery. So the government kind of backed themselves in a corner there. I thought it was a really good summary of the law that we were challenging. They did a really good, judges normally do. They put together a really good program. But then he goes through the lottery and how that worked and who was picked. And, you know, it was, I mean, that we can't be unhappy with because he did tell the truth. But then the judge gets to the main part of the case. All right. After he gets done with standing, he basically says, look, plaintiffs have 2 claims. They have 2 claims. The first claim is the statute speaks in terms of alien, which is a foreign national, anybody who's not a U.S. citizen, and that the visas are counted as foreign nationals. And the judge even quotes the statute in his decision where he emphasizes alien, alien, alien. I mean, this is, for example, and the judge points out that the controlling case here is a case called Chevron. Now, it's a gas station, but what is Chevron, Aaron? What does that mean in our context?
Yeah, Chevron it's an old case that says if there's an ambiguous statute, it's not really clear what it means, then the agency gets to interpret it, and then courts will defer to that interpretation as long as it's reasonable.
Even if the agency reading differs from what the court believes is the best interpretation. Mm-hmm. It's a very high bar. Now, oddly enough, it is a bar that at least 2 current sitting court justices want to get rid of. And it's a big thing a lot of conservative judges want to get rid of, because why should you defer to the agency if its language is plain on its face? So that was an uphill battle. We knew it was an uphill battle. It wasn't our strongest argument, for sure. Basically, the judge says, look, we argue that the act is unambiguous in allocating visas by each foreign national. The problem is, judge says, with the registration rules allocated by registration, the rule ignores the law. And because the law is clear, there's, you don't need to get to Chevron step 2. It's quite clear. So here's what the court said. The court agrees that the act directs the agency to allocate H-1Bs by foreign national. So the statute is unambiguous. It's clear about this. But, he says, our characterization of the conflict between the law and the rule depends on us conflating alien with registration. And that because the word registration appears nowhere in the statute, there's no conflict. That's basically what he said. Now, you can't have a registration without an alien. I mean, you just can't. But, that's the judge's rule. We want to fight that. We will have to appeal. Okay? I'm not sure we'll fight that, but that's what he says. He says, look, the government's argument, it's an antecedent to the law taking effect. Okay, we made the argument. He didn't agree. The standard was very, very high. So there you go. Now, we did not challenge, and we specifically didn't challenge the registration itself. I think the registration is quite legal. I mean, they can have a registration. Okay, it's just that how they did the registration was our challenge. So the court never got to the second step of Chevron because I didn't think we had an argument for it anyway. Okay, so that's issue 1. The second issue for us, as the court said, the law is clear. 1 alien, 1 registration, and what matters is that USCIS only issued 1 visa to each alien, and that's boom. That's there. All right. So the last issue, the big issue for us, was whether the Immigration Service followed the Administrative Procedures Act. Now, this is a big deal. It's a very special law that says when an agency enacts a regulation, there's certain things that they have to do. This is actually the law in which that courts strike down the MPP change. They strike down the DACA case because the government didn't follow the APA or didn't follow it correctly. And the government here did follow. I mean, they used the APA. They published the rule. They took comments. But our position was that they basically rejected very important comments. They superficially wiped over the rule. I mean, so when major employers, including the U.S. Small Business Administration and the U.S. Chambers of Commerce, say, this is open for fraud and abuse, it's going to be a major problem. The judge said, well, let's take a look at that. So we argued 3 reasons it's arbitrary and capricious. First, they failed to examine and meaningfully respond to the comments. The law says they must consider and respond to significant comments received during the period. 122. For example, he says the small business registration warned companies would try to flood or dilute the registration pool, making it different for small businesses to obtain essential H-1B slots and workers. And we know they glossed over that. We gave the effort on that. And here's what the judge said. We said this. Because the department did not adequately respond to the comments, we contend they failed to demonstrate the rationality of its decision-making process by responding to comments relevant. Here's the kicker. This is this quote. The applicants set the bar too high. Well, you know, my dad used to say, better shoot for the stars and miss than shoot for a cow pie and hit. So basically he said, quote, it is settled that the agency is not required to discuss every item of fact or opinion, including submissions made in informal rulemaking. Need only enable us to see what measures the policies were ventilated and why the agency reacted to them. I don't think they meet that minimum standard, personally, Aaron. But the judge clearly thinks what we were asking the government to do was more than the government was required to do.
Well,
we were wrong. He didn't say we were wrong. He just said, yeah, it's a little too much.
Yeah, what he says is that when they responded to the comments, the overwhelming public comments saying, hey, this new rule is going to cause a flood of petitions that are not bona fide. What the judge said was that the agency's response of saying that they will review the beneficiary's qualifications and will refer evidence of fraud to the USCIS FDNS. That's the fraud detection and nationality.
That's a different thing.
And he says that is sufficient. They said that they would do that.
But that's a different thing. The judge conflated, and he also said this, that USCIS would review the application. They would review for duplicate registrations. We weren't challenged. Duplicate registrations aren't allowed by employers. Right. That's what CIS. So he conflated two other things with the fraud we were talking about. I think that's an error. And I guess we go back and ask him to reconsider his case because that's an error. Those things don't refer to the first thing we're complaining about. All right. So there's that. We think he's wrong on that, but I don't know what he would do if we file a motion for reconsideration. Second, the applicants argue they ignored matters of importance, which we believe they did. The judge says that in response to that, that we argue the intent of Congress was not to do this. The judge says this is not really a registration rule problem, so I'm not really going to get into it here. I don't need to consider that. Third, we argue that they failed to articulate a satisfactory explanation for its answers. We argue that the department ignored empirical evidence and fact, and basically just didn't do what they should be doing. And he said, you're dressing up old arguments. The agency need not address every argument provided explains why it acted it did. But again, what he's relying on what they explained why they did is not what we were complaining about. It's a different thing. So that's kind of where we are on the decision.
One other point. Near the end, he said he acknowledges that we notified the court that they've added this attestation. And our point was, listen, the agency is basically acknowledging that they have a problem here. And what the judge said was basically that may be true, but good for the agency in doing something to fix it, and that's okay. That's what agencies do.
So, and the litigation forced them to do that. So that's the decision in the case. That means that the lottery move forward as it's currently fixed in the H-1B raffle context. I am curious to see. I know some of our plaintiffs have said maybe 500,000 applications. That was before, of course, the statement about the registrations and the attestations by employers. But Aaron, there's going to be a lot more than last year. I just think there are.
Well, the demand for workers right now is out the roof. I think it's going to be a really high number.
Absolutely, unless Dick Durbin and Chuck Grassley's proposed legislation, which could pass as early as next Friday, as part of the omnibus spending bill, which would basically reorder how the lottery is located, and it's no longer based on luck. It's mostly based on where did you get a graduate degree from? Are you a STEM holder? How much are you getting paid? Which, of course, Congress can do. I mean, Trump couldn't do it, but Congress could do it. And if they do that, then keep in mind, Congress also knew we were litigating this. I mean, we've been in touch with Durbin's office. Grassley's office reads the paper, and there's been a number of articles about this case as well. So, thank you for those that reported on this because it remains a big problem, a big concern. So, for a lot of our plaintiffs who are getting paid very well, who are working with large companies, who have STEM degrees and master's and PhD degrees, the change that Grassley and Durbin are talking about would benefit you tremendously, I think. Aaron, let's go to some comments and questions here as part of it. Francois Gilbert just wanted to say hello, as he always does. Easy Cog, good to see you. Good to see you, Osama. We got Chris. The body shop already abusing fraud. Why you can expect moral restriction? Well, I was saying a decent person would have a moral restriction. I didn't say a body shop would. Let's see. Oh, yeah, Francois, you are now in Texas. I don't know if that's a good thing or not. Being in Texas.
Texas is a great place.
It is a great place, though. I notice you don't live there. You say that and you don't live there. You live in a very high place in Colorado in more ways than one. Abshek, Rapelli, very disappointed that it's so rampant. I don't want to go to Canada yet. Let's see what Mr. Grassley and Mr. Durbin have up their sleeves here. I think.
But I'll tell you what. I mean, to his point, he's right.
Yeah.
We're gonna work ourselves into losing lots of people to other places like Canada, and we'll suffer for it. So,
Aaron, I was part of one of my law school classes today. We were talking about H-1Bs and about this case, and somebody noted, a couple weeks ago, Professor Cook, you said there was about 800,000 foreign students in the United States, but now you're telling us there's only 85,000 H-1Bs a year. Well, even if nobody came from out of the country, that's not even enough to handle all the graduates who might want to stay in the United States. And I said, exactly. I mean, when they created the cap, of course, there was it's not based on any math or anything, just a number they picked out of thin air. But we didn't have nearly the number of foreign students we have today. We're probably going to get back up to 1 million by the time Biden's done out of office. And we still have 85,000 H-1Bs. It's just stupid. So you're right. I mean, Canada has no limit. I mean, companies are opening up offices up there. You're right. I mean, I agree. And doesn't mean we won't come back later and say, Judge, where's the facts? By the way, we have not decided whether we're going to appeal. I don't know if we're going to appeal. We have 60 days to decide whether we're going to appeal. Within that time frame, we will know how many registrations and how many selections in the first round. So that might give us a lot more ammunition for next year as well. We'll see. Now, Junlin, if I'm going to correctly registration saves time. I agree. I mean, that's the thing. We were never opposed to a registration. I mean, this is way better. That's, IT serve come in because you're going to destroy, it's going to cost us $50 million. It's not what we were after. We just want a fair lottery. A fair lottery. This is not fair. Do you appeal? Nah, I don't know. I just don't know. Clearly, the judge has a factual error in his primary basis on our argument that they did not respond to the comments. Because the two items that he hand selected that were responses to fraud were not responses to this fraud. So I think it's a big deal. Simon, I mean, this is the DC circuit. They are the circuit on government regulations. A lot would depend on the panel we get. Obviously, if you lose down below, it's a lot harder to win up above. So the answer is I don't know. I mean, generally speaking, most people don't. Most appeals are denied. Just generally speaking, that's true probably everywhere, Aaron. On every appeals court, most are denied. So I don't know. We will do a detailed analysis and decide. But let's gather some more facts first. We will continue to shout from the rooftops. Now, if immigration in mid-April says, hey, we're going to publish a new regulation about how we're going to do the lottery next year, or Durbin and Grassley change the law, then the case is over. We don't have a case. Thank you, Joe. Good to see you again. Chris, one day my grandson can see that bill pass. The thing about the Grassley-Durbin thing is it's in the omnibus spending bill. And it also has Greg's managed to get a doctor component in it, by the way. Greg, Greg knows people. The man knows people. And so it has a really good chance of being in the omnibus bill, which is a spending bill and has to pass. That's how immigration bills get passed. They don't get passed on their own, especially after that wildly weak-butted immigration shout-out by Biden last night. Let's enforce the border and we should change immigration laws. Really, that's a big nothing burger. My wife chose wallpaper color. It was, what are you talking? That's not wallpaper. That's a painting. I decorate my office. Trust me, my wife does not decorate my office. Aaron could use a picture or something behind me. Put a llama up or something.
I just moved offices, so I don't have anything up on the walls yet. I've got Girl Scout cookies behind me.
I was noticing, that's a box of Thin Mints.
Yeah.
I'm a huge Tagalog guy. I mean,
me too.
Kind of my favorite. I like the Samoas, but they give you a diabetic coma if you eat more than one. So
that's true.
Sergio, what was the immigration Twitter sentiment on SOTU, Texas primary results? Aaron?
The State of the Union, like Chuck said, you know what? The president comes into power with his coalition, and the immigration reform community is a big part of that. And they say really nice things during the campaign, and they say really nice things about ending detention and about immigration reform. And then when he's in power, it's the State of the Union. And what does he say? We need to secure the border.
Why don't you say the border is very secure? We deported over 1 million people last year. Since I've been president, I've deported 1 million. I deported more than Obama. I deported more than. Why didn't he say that?
Yeah, if that's the constituency he's trying to appeal to, maybe he should have.
Well, clearly he's not appealing to his base.
Yeah.
I mean, that's quite clear. Ju, what we already talked about what we can do. We might appeal.
Oh, wait. Sergio also asked about the Texas primary. Were you following Cisneros versus Cuellar?
That's still up in the air, right?
It's going to go to a runoff.
Is it going to go? Because they were still waiting on some votes or something like that.
Last I saw, it looked like it was going to go on a runoff. So
the dude is under indictment. Well, not right. He's been under FBI investigation for international money laundering or something. It's crazy stuff. And people still vote for him. The thing is, he's basically a Republican.
Yeah.
He's basically a Republican. And that's very conservative Democrats right there. Very conservative Democrats. I think he'll probably win a runoff. Probably.
I hope Cisneros beats him, but
that would be great. She'd be awesome. But she might lose a general election to Republican in that district.
Maybe.
But but that would send a message to liberals too, right? One thing I didn't. Did Paxton get over 50%? I think he's going to a runoff. The crazy attorney general, who is under indictment, only got like 41%. And George P. Bush was running against him, but he didn't even come in second. Somebody else came in second. So crazy. And that was in the primary, of course. What else can we do? Well, we can appeal, but we're going to wait and see what happens now. Because we have to. We're just not going to jump into an appeal. And I'm also going to think about the motion for reconsider, or if that's something we want to wait for purposes of an appeal, because I think it's a legal error. It's legal factual error. What changed on the horizon for next year's lottery? I think you're going to see. Well, I do think that the Durbin bill would probably pass. It's got the 2 Republicans on it. Nobody's going to oppose that being in the bill. That passes. Next year's lottery is a very different creature on registration. They might even have subcategory. Maybe they have separate subcategory. I don't know. Basically the number one category will be, do you have a master's or a PhD from a U.S. university in a STEM field? And if you do, you're getting an H-1B. Period. You're getting an H-1B, and then everybody else would fight for the detritus thereafter. And if you're a bachelor's degree holder in sociology, don't count on an H-1B. That'd be what I'm telling you. And if you don't have a U.S. degree, you're definitely not getting. Basically, it'll shut down the IT industry, the job shot. It'll shut them down because very few of those guys have U.S. degrees. Completely shut them down. You tell me whether that's a good thing. Chris, but the USA did not disclose selection of every year. I actually, Chris, filing a Freedom of Information Act request on that exact point, because I want the numbers from the last 5 years. Now, I did file one of these, by the way, Aaron, 3 years ago, And it took them like 2 years or a year to respond to me. And they said, hey, all that's information on our website. But it's not, because I asked for specific breakdown. So we'll see what we get. And they have the numbers, obviously, because they're tracking the numbers, right? Jack, is you? I think these love Willie McFadden. Well, maybe you would. Trust me, it would depend on which judges you get. And apparently we don't have Ketanji Brown Jackson anymore on the bench there. We can still request selections of each of the three. Yes, we are going to be doing that. Sergio going for Cisneros. There you go, Sergio. All right, HC, Ms. Kirk, what did you opinion on the Declaration of Unfairly Increased Chances of Selection? Knows only what does stop five multiple becoming ordinary. Well, I think it'll have an effect. I think it'll have some effect. But there's so many bad actors out there. They're just bad actors, bad players out there. And what's the downside, Aaron? There's no crime. It's not a crime to do it. It's not even a regulation. It's a policy. If I'm an employer, I'm going to say it's not a regulation. You can't, you want to enact a policy that changes the rules. You got to go through the APA. I win that case. So, I think it will reduce a little bit, but I also think, Aaron, there's going to be a high demand of legitimate H-1Bs, of legitimate ones. Emily Dietz, what are the chances for pathway decisions for DACA recipients? What is going to happen to DACA? Nothing is happening to DACA. Although today a new coalition was organized, U.S. Chamber of Commerce, National Farm Workers Association, like the Idaho Agricultural Department, and some law enforcement group are working with Immigration Forum to pass DACA and other reform green cards. So, but I don't see it passing. I don't see how it can.
Yeah, I'm not optimistic either. And the only thing that's more worrying than that even is the Texas judge. It's not Tipton, it's the other one, right? Who still has this case before him.
Yes.
So what's his name? It's I'm blanking on it, but he's the one who, if I remember the posture right, his injunction stopped them from accepting new applications,
right?
But there's still a potential that his decision on the merits could strike down the.
But I think that case becomes moot once they've gone through the APA, because this whole decision is based on the APA, and they've gone through the APA. So the question is, where's the freaking regulation?
Well, yeah.
Where is it? What are you waiting for? Maybe it's in the same place as TPS for Ukrainians. I don't know. Or Afghans. Why is there no TPS for Afghans?
But I'll tell you what, they publish this regulation. We get a new regulation. Texas is going to run to the court a week later and say, that regulation will survive.
I don't even see this guy overturning a properly completed APA regulation. I don't. I think they would go all the way to the Supreme Court in a couple of weeks and get that overturned.
I like your
Dad. I'm not Mr. Confidence.
Yeah.
On this stuff, but I think that's a legitimate thing. What about Go? We talked about Go yesterday. Go wait. That's what Go wait is doing right now. We're waiting on Judge Mehta, who is taking his own sweet time, making a decision on the stay, which I love. That's great. One thing the U.S. government is good at: malicious FOIA compliance. So, FOIA, FOIA. You type like I do, Dejun, and I type terribly. Thank you, Janessa. You're very kind. Vignesh, what's the guarantee you publish anything about the first round? Oh, I don't think I don't see that happening. They're going to keep playing to hide the ball, which is why, Aaron, we're actually going to probably do this on Impact. We're going to be aggressive on this FOIA. We're going to give them 20 days. And then we're going to appeal it for non-response. And then we're going to give them 20 days. And then we're going to federal court. Sound like you ready? You ready to have fun? Want to be my lawyer? It's going to be fun. FOIA litigation is a blast. 2021 lottery. I assume he's talking about DV. That's Go. That's still pending. So, here we are. We've got this whole thing we're working on, and it's not over. But again, it's a battle we've lost to this point. But the war, we're winning this war. We will win this war. And that ultimately is the goal. So, Aaron, I don't have any more questions. I know you've got to sell some Girl Scout cookies. One more question. What will be the risk for multi-registration this year? Well, That's a good question. If somebody submits 3 legitimate real employer applications, there's none. There's no risk. If they submit a dozen crappy ones that are from companies that are related, I think there's a high risk that they're completely disqualified. Or that they face immigration fraud charges. Remember, it is a crime to commit immigration fraud. It's a federal crime. So they could turn it over to FDNS, could turn it over to the U.S. Attorney's Office. So yeah, you can go to jail for visa fraud. All right, Aaron, you have a great day. You are live tomorrow. Is that right?
Tomorrow at noon. I'll see people
noon,
there.
Noon Central, which is
Noon Mountain. Don't forget about the forgotten time zone, the Mountain Time Zone.
Mountain Time. I love the Mountain Time. My wife has just got back from the Mountain Time Zone, and I'll be heading there in a couple of weeks. All right, Aaron, my friend, you have a great day. Oh, by the way, Greg is off accepting the Impacts Award on the use of technology in litigation. So congrats, Greg. Thank you very much. Thank you, everybody. Have a great night. And by the way, we will send around a redacted version of the decision as soon as we can get it redacted. We got a couple things we need to file today, so we're going to get that out probably tomorrow. Bye-bye.
Thanks all.